Hello and good morning, everyone. Thank you so much for being here today, and welcome to the Law Development and Enforcement Workshop. My name is Sean Spears, and I'm a part of the British Columbia Support Services team with the First Nations Lands Management Resource Centre. I'm going to be your facilitator for this session today, which is being recorded, and we will also be taking notes of any of your feedback or any of your questions. And the recording, as well as all of those notes and questions and feedback, will be available to everyone after the session. So for those of you who are not as familiar with the Resource Centre, we are a First Nations organization dedicated to serving and supporting First Nations communities who want to reestablish control over their lands, natural resources, and environment through the historic government-to-government framework agreement on First Nations lands management. The Resource Centre was established by the Lands Advisory Board to undertake its technical responsibilities to framework agreement signatory First Nations through support that provides resources, curricula, and training programs for the development and implementation of community land codes. The RC provides First Nations with support and assistance during the interested, developmental, transitional, and operational phase of land governance. The support services team is the first point of contact for First Nations wanting to access all of the land code governance training, supports, and resources that we're going to be talking about today. There will be time at the end of this presentation for questions, comments, and discussion. And if you're not comfortable with speaking or you're having technical difficulties, please use the chat box to post your questions and comments. Or you can direct message any of the support staff here today. And if you're worried that you're going to forget your question, please feel free to post it in the chat box straight away, and we will get to as many as we can at the end of the presentation. So we've got three fabulous presenters today. First, we have Kevin Broughton. Kevin served 33 years with Ontario Provincial Police, and he currently resides in Thunder Bay, Ontario. Kevin served across Ontario in a number of capacities, including provincial constable, identification constable, and the forensic unit. Kevin also worked extensively with First Nations communities throughout Northern and Southern Ontario. He also worked for the Ontario College of Trades as an inspector and manager of investigations, court hearings, as well as worked as a project manager for the college records management system. We also have Gail Starr. Gail is a member of Seabird Island First Nations in the Stolo Territory, located in the Upper Fraser Valley of BC. Gail joined the RCMP in 1997 and worked all over Northern and Southern BC before being posted back in her home territory. After 30 years of service, Gail retired from the RCMP and joined the Resource Centre as an environment and enforcement advisor. And finally, we have Michelle Bouvier. Michelle is a member of Muskeg Lake Cree Nation within Treaty 6 territory in Saskatchewan. Michelle attained her Juris Doctoral degree from the University of Saskatchewan, where she concentrated her studies on First Nations legal issues as well as corporate law. After being called to the bar, she worked in private practice and represented hundreds of residential school survivors within the independent assessment process. She's also spent time as an instructor with the College of Agriculture and Bioresources and the College of Law at the University of Saskatchewan. Michelle's practice has focused primarily on Aboriginal, environment, and corporate law, and she has experience in specific claims, land and economic development, and trust law. Michelle also recently welcomed her first child into the world, so on top of all the professional accomplishments, she's also a busy mom and an avid golfer. Amazing presenters, I will pass it over to
you. Good morning, everyone. I just want to kind of give you a little bit of a rundown of what's all going to be included in today's presentation. First, we'll start off with a bit of an introduction, looking at what we're going to see in the framework agreement with respect to law development and enforcement. We'll look at the creation of laws, resources and support for law development that we would offer, enforcement and adjudication, different measures and examples that we can provide for you. We'll also discuss a bit of dispute resolution and discuss legal advice in terms of developing your laws for your First Nations. And of course, enforcement project funding is always a big topic, so we'll discuss that closer to the end. So first, what I wanted to say is that this session is targeted for Land Code First Nations and framework agreement signatories and those that are interested in the framework agreement itself and general law development from that. So we're starting off the basis of what is a land code. We're talking about a land code being the basic land law of your First Nation, of a community. It's drafted by the First Nation and ratified by your membership. It replaces the land-related provisions of the Indian Act and establishes a system of governance and administration for the management of your lands and natural resources as well. So just more of an introduction here on the framework agreement and your land codes. It's First Nations that are operating under the framework agreement are the primary governments over the reserve lands. So you are replacing those 44 sections of the Indian Act, and this governing authority includes policy, planning, lawmaking authority over your entire land base, even lands that are occupied by individual members, non-members, businesses, and visitors. Federal government recognition of this self-government over reserve lands is an important signal to other governments, provincial, territorial governments, and businesses, non-member residents, courts, police forces, and so forth, that Parliament recognizes this exercise of self-governing power. Next slide. So when we talk about lawmaking under the framework agreement, we're looking at specifically section 18. I'm not going to read you the entire section, but if you were to take a look at it, it's quite extensive. So I will say 18.1 of the framework agreement, the Council of a First Nation with the land code in effect has the power to make laws in accordance with its land code, respecting the development, conservation, protection, management, use, and possession of First Nations land and interests or land rights and licenses in relation to your land. So this includes lawmaking powers on any matter necessary or ancillary to the making of laws in relation to First Nations land. So when you're making laws, it's quite a broad authority that's given under the framework agreement. That's the simplest way that I can put it at the moment, but you generally have such extensive authority, which my colleagues will discuss in more detail, and we'll get to some specific examples for you throughout the presentation and closer to the end. So, enforcement. Enforcement under the framework agreement is a very, very large topic as well. We've had throughout the past years, as long as I've been at the Resource Center, it's like, okay, well, we've expanded jurisdiction under the framework agreement. We have all of this lawmaking authority and presence, and we're slowly, but with all these laws, how are we going to enforce them? What can we do? And that's the biggest question of all, and typically the hardest. So framework agreement First Nations laws are designed to work alongside applicable federal and provincial laws. So an offender might be charged with a violation of a First Nations law as well as federal or provincial laws for any actions on First Nation land. So you can, let's say you have a law specific to the environment, you can charge them under that, but you can also charge them under any federal environmental violations at that point. So they can overlap, and it's basically to encompass the full protection of, let's say, for the environment, for example, over your lands. The framework agreement provides for enforcement of First Nations laws on summary conviction. So we're looking at summary conviction. That definition you can find in the criminal code. This includes fines up to $5,000 and up to 6 months imprisonment. The framework agreement provides not just for penalties through fines and imprisonment, but also restitution, community service, alternate means for achieving compliance. These are all listed in section 19(1) sub B of the framework agreement. So you can have all of these like penalties, fines, and it's fine to have all of this, of course, but how are you going to achieve the justice that you're potentially seeking if you have offenders who are unable to pay such fines? So we can look at other options under the framework agreement in establishing your laws for enforcement. You can look at dispute resolution, of course. You can look at community service. And you can have anything that's more specific to your community and go that way. So I think it's a very helpful thing to have. There's clear authority under the framework agreement, of course, to establish in First Nations laws your comprehensive enforcement procedures that are consistent with federal law, including inspections, searches, seizures, compulsory sampling, testing, and the production of information. I know Kevin will touch on this a bit in the presentation as well, gathering of evidence and that sort of thing. This is the specific section I just listed here as 19(1)C of the framework agreement. And it's Kevin. I'll pass it to you.
Okay, good afternoon or good morning, or whatever side of the country we're on. It's afternoon where I am. One of the areas that we talk about is how to create your laws. And Michelle has highlighted the sections under the framework agreement that give you the authority to create your laws. But now when it comes to looking at what type of laws you need and that, there's some steps that need to be considered. Some examples of your laws that you can create are environmental protection laws, animal control laws, an enforcement and ticketing law, zoning and land use laws, community quality and protection laws, along with matrimonial real property. These laws provide not only enforcement when there are offenses, but also periodic inspections of business projects, leases, rentals, and ongoing projects when it comes to environmental projects or building projects. When you have expansion and development, you need somebody to conduct inspections and make sure that the contractors are doing what they're supposed to be doing, following the rules, not contaminating the water. And that could be providing dikes and water flow protection. So so the first step in your how you create the laws is assess what you need for a law. Are there any existing laws? Again, the framework agreement does not prohibit the use of Indian Act bylaws that have historically been troublesome for police and enforcement agencies to work with. Some of the shortcomings of the bylaws is providing the authority for the individuals or the enforcement personnel to actually carry out their duties. It goes right to the heart of the problem, such as a trespass law. So when we create these laws, we're looking at proper definitions, proper authorities, delegations, appointments for individuals and their authorities to work within the community. Some First Nations communities have implemented or are in the process of implementing a ticketing system. The ticketing system can issue warnings, written warnings, fines, and again, under these an enforcement and ticketing law, you can have cease and desist orders. You can have stop work orders for the inspectors, and penalties if you violate those. In many communities, very few tickets are issued and should be looked at as a last resort. Compliance is the focal point of enforcement, because if you end up going to the court system, which ultimately for the more serious and repetitive offenders, the option is, as Michelle outlined, use the summary conviction provisions of the criminal code, where you would issue a sign an information, issue a summons, and appear before a provincial court judge. Now, the Resource Center has had one case. The Comox First Nations hired a private prosecutor, and it was a landlord-tenant dispute where Justice Gordy actually ruled on the recognition and acknowledgement of Land Code First Nations, and that the community was afforded a remedy. Ultimately, the case did go to court, and that the two individuals who were non-members were fined, and they were part of their sentencing was a lifetime banishment from the community. So again, now that is a court order. Do you need an actual law to address the issue, or is this something in the foreseeable future? How does the community wish to enforce these laws? And I've talked about the three or four ways that we can enforce these laws: ticketing, inspections, provincial court, and one area that I would like to highlight is you can use your traditional means or under your customs to include in writing these laws. And that's one area that should be remembered: using the elders, using any healing circles or whatever is customary or through your traditions. Use those to be a very valuable enforcement tool. Next slide, Sean, please. And over to you, Gail.
Thank you. Hello, everyone. I'll be continuing with the creation of laws, and I'll be talking a little bit about how those laws work with each other. The ERC can provide support for the development of a wide variety of laws within the authority of the Framework Agreement. An enforcement law, or the example of some of these laws are enforcement law, ticketing law, residential law, or MRP law, and environmental laws. Development of an emergency law such as COVID-19 to deal with urgent situations that threaten the health and safety of our community in accordance with your land code. But going back to the enforcement and ticketing laws, they work alongside each other and they work alongside other laws. This law has the enforcement authority to authority explained rather than repeating this in every law. This law can be updated as needed without having to amend all the other laws. Many laws can be linked in various ways. An enforcement law may be linked to an MRP law by process. A residency law can be linked to a trespass law, and all laws will use processes embedded in the enforcement and ticketing law. So it is important for communities to develop their enforcement and then ticketing law. Land Code gives the First Nations community the ability to develop an emergency law, such as community protection law. With the COVID-19, the communities need to act fast to put measures in place to protect and assist in stopping the spread of infectious outbreak in their communities. Over to you, Michelle.
Sorry about that. I guess it was on mute, but I'll start my spiel over again. So one of the big things under the framework agreement is the creation of matrimonial real property laws, or MRP laws. So this is one of the largest areas that I've been working in most recently, I suppose. If you were able to join in Catherine McHugh's session yesterday, she did a very, very good overview of MRP, you know, the types of things we see. She included case law. She went through the Family Homes on Reserve and Matrimonial Interest and Rights Act, which I'll term FMIRA because nobody wants to say that acronym that many times. It's exhausting. But anyway, so under the framework agreement, you have First Nations have a full jurisdiction to address the legislative gap respecting on reserve MRP rights and interests. This is something that the framework agreement established early on, like to recognize that there was this extensive gap for those living on reserve that didn't have the same protections and rights as those individual First Nations or non-First Nations living off reserve. So now First Nations have the authority to create their own system for making reserve land allotments as well. To individual First Nation members, they also have the authority to deal with any of the MRP interests or rights that other, let's say, provincial legislation could deal with. First Nations are responsible for enacting rules and procedures in cases of breakdown of marriages, respecting the use, occupation, and possession of First Nations land, and the division of interests in First Nations land. So we saw some amendments in 2018, some pretty substantial amendments to the framework agreement for First Nations operating under their land codes. So now those amendments provided for the full range of MRP authority currently available under FMIRA. So FMIRA came in with their legislation, I believe 2013, 2014, and it was very substantive, although very closely mirroring what we'd see in provincial law. So not necessarily what every First Nation is going to want. I'm not going to say that it's a good thing or a bad thing, whether or not the First Nation chooses to enact FMIRA or their own laws under the framework agreement. But regardless, these new amendments from 2018 to the framework agreement expanded upon the current authority to deal with the breakdown of a marriage to now include the death of a spouse. So prior to that, we didn't have the inclusion of that death of a spouse. And also the amendment saw the total elimination of what was that 12-month waiting period for First Nations to make MRP rules. So prior to 2018, it was that First Nations who enacted a land code had to, within a 12-month period, to make their MRP rules. And that's, if you think about it, and if you think about all the time it takes to create a law, whether it's environmental law, MRP is such a huge, it's very, can be a very sensitive topic for members to deal with. So it takes a long time, and it's, you know, on top of everything that your nation is getting ready for and dealing with your land code and other provisions, it's your MRP. Developing it in a 12-month period is a little unrealistic, and sometimes I think it's of course it can be done, but so now we have that 12-month period gone. Can we just go back for a second? Sorry. And then the elimination of dispute resolution with Canada and regarding land code provisions. Sorry, you can keep going on the slide.
In this slide, I'll talk about resources and support for law development. The RC staff from the enforcement team and technicians can work with the lands manager, committee, or group charged with the development of those laws. The enforcement team can work with your legal counsel using existing laws or samples. Each law should be individual to the community. Staff can meet with chief and council or the committee to assist with the development of your laws, discuss possible investigations and charges. The RC staff hosts a variety of specialists who can assist with the development of those laws. We have law enforcement, environmental specialists, waste management, GIS, land use planning, traditional knowledge, and land governance planner. You will find in the RC website samples of laws from across Canada, or if requested, we can send you a sample of specific law to whatever law you're developing. Our staff has compiled sample laws that can be modified to meet the needs and requirements of your community, but we must caution you to avoid using these sample laws as templates. So meaning avoid cutting and pasting the names of your First Nation to the sample law. Some of the sample laws that we can provide for you, and the website you can see on the slide, are samples of emergency management laws and emergency plans. The problem with cutting and pasting an existing law is some areas could be missed. Some things that could pertain to your community may be in the law and it really doesn't pertain to your community, so you need to make those adjustments. Working on a law with a community, for an example, working on a law with a community, no one had noticed in small print at the bottom corner of the law was the name of the original community who first drafted the law. So it wasn't until the group had finished the law and they're reviewing it, ready to pass it on to the next level, and they noticed that a name was at the bottom. So you really do have to be careful with cutting and pasting, and you got to make those laws your own. You got to review and review and review and fine tune it and ensure that everything in that law pertains to your own community. Next slide is for Kevin.
Thanks, Gail. The Resource Center and our enforcement team can provide advice on potential cases and determine if the evidence supports those charges, and as a high probability of conviction. How do we do this? Our team has experience and knowledge to screen potential cases, determine if the evidence will provide a high probability of conviction. It's not just the number of charges that you take to court, but having quality charges and quality evidence. One thing that we're trying to avoid is bad decisions, and which potentially provides bad case law. And once case law has been made and entered into court, then that can be problematic down the road, as other legal arguments can rely on that case law. We can assist the enforcement officers as case managers. We cannot get involved as investigators. We can advise how and what collection of evidence. Again, as Michelle mentioned, we must follow the rules of search and seizure and the Charter of Rights and Freedoms. There are certain conditions and ways that you can gather evidence and what you have to do with that evidence once you've gathered that. We can assist and direct you how to compile the documents and even how to set up your reports, and finally assembling a Crown brief. Now, for those that aren't familiar with it, a Crown brief is like a report and almost like a book, and it sets out the entire investigation. It can be quite lengthy, or it could be very simplistic if it's a trespass or that. But if you get into environmental charges, you have inspections, inspection documents, and how you seize them. So it could be quite complex. We also would work under the direction of the prosecutor. As I earlier indicated, Comox First Nations had to hire a private prosecutor. So this is a lawyer who represents them as a prosecutor, and they will present the case in court. We work with the prosecutor to help prepare the staff for the court appearances, get them ready to testify and that. So again, we provide those services to the First Nations. We'll engage with the prosecutor and provide any assistance to the prosecutor, looking at strategies, what evidence is needed, and ensure that it has been gathered properly. Next slide, John, please. The First Nations communities can face many challenges with law enforcement, local enforcement agencies, and court service administrations. The enforcement team can assist in bridging those gaps with those agencies. So what can we provide? We can provide education, information, and develop and promote those relationships. Many of the police services and supporting agencies, much like the SPCA, local municipalities and that, are not fully, doesn't have a full grasp on what land code is and how those authorities fall with the First Nations. We can provide training and support on enforcement and adjudication under the framework agreement. We speak to provincial court officials and try and get recognition and acknowledgement for the courts. We will, as I've indicated, will ensure on and work with each case on to provide both operational and guidance, and the possibility of financial support. And this is all subject to approval to assist in the prosecutions. Some of the questions that you might ask: do you have an enforcement agency within your community? Is it the RCMP? Is it a security firm, or is it a tribal police? We can reach out and speak with detachments, police services such as any tribal police, provide any education on the framework agreement, those authorities under your laws, if they're written in. We'll assist with policing agreements. Do you have any policing agreements with the local detachment or the police service? What are your court service agencies in your community? Do you have to travel to a provincial court, or do you have a local court that comes out periodically, maybe once a month, and they have a court in your jurisdiction? Is the community looking at using a security company? And a security company, there's challenges with using a security company. They don't have the authority, unless the authority is written into the laws, to effect arrests, and that's a whole other area that has to be considered by your community. Is the company a registered company, and are they trained in enforcement of land code laws? Again, providing the proper training to security firms, along with having a properly designed and drafted agreement, is paramount. Once you sign that agreement, the community, along with chief and council, should be considering the liability of the actions of the security company. So these are all areas that should be covered and discussed in length, because you don't want the security companies acting on your behalf and doing something outside the law, which you could be named in a civil suit or jeopardize the investigation. Next slide, Sean. The Resource Center engages with many government, provincial and federal government agencies. One of the areas that we try to engage is through the National Online Conversation on Indigenous Laws. The website there listed on the screen, you can access when these upcoming webinars are. It's a series of enforcement webinars promoting dialogue between Indigenous governments and the Government of Canada. There's guest speakers that provide insight, and that, again, the First Nations communities face many challenges when it comes to local enforcement agencies and trying to bridge those gaps. Just recently, we had one, and it was very well received. Again, there didn't seem to be enough time in the 3 hours that we had for that discussion. So the Resource Center, in cooperation with other agencies, provide this discussion through the online conversation. The online conversation is a national forum, not only open to Land Code First Nations, but all First Nations, Métis and Inuit, and government officials, opening the discussion on enforcement, drawing together Indigenous governance experts to provide a further understanding and support and the recognition of enforcement of Indigenous laws. What other agencies do we engage with? Well, it's the local police service, municipal and regional managers. It could be through animal control. It could be through a crime prevention, through an environmental design. We meet with any of the agencies that access or you would like to have access to. And through our technicians, our staff, our enforcement staff and our technicians will sit in on any committee meetings and meet with any of their staff to help understand and guide them through the framework agreement. Sean, next slide, Sean, please. Again, the Resource Center has embarked on several letter writing campaigns across Canada. We continually meet with both the provincial and federal ministries on enforcement. As a result of the campaigns, the Resource Center has received acknowledgements that there are deficiencies in enforcement for First Nations. We're awaiting a response. We've applied to sit as a member of the working table as a pilot project in Ontario involving federal, provincial, First Nations police and regional policing agencies. This was soon after we received acknowledgement from a letter writing campaign, and this now will provide a discussion not at the federal level but both at the provincial level, and the hope that this working table will be expanded across Canada. So the continued engagement with the courts for the recognition of First Nations laws and the appointment of justices to preside on the bench. The framework agreement provides that a First Nations community can appoint their own justice of the peace. The challenge is that those justices to sit in provincial court, which are run by the province, we need acknowledgement that they've got training, either through an agreement or a present sitting justice that would represent the First Nation. Again, these are all part of the organizations, the letter writing campaigns, and sitting at these tables that we can move the yardstick to allow a justice to be appointed by a First Nation to adjudicate First Nations laws. Next slide, Sean, please. Some First Nations communities have a formal dispute resolution program or system. In many of the land codes, when they're developed and voted on, there's a section in there for dispute resolution. It's an informal restorative justice system and can be used outside the court system. What are the advantages for dispute resolution? Number one, it saves court costs and legal costs. This is an in-house dispute resolution process. It saves time. Just for an example, the Comox case in BC, the papers were filed, I believe, in March. The first hearing was in May, and it was not actually set for trial until September of that year. So you've got 6 to 9 months that you have to wait to get a problem or a dispute discussed and acted on. The main purpose is to achieve an early and amicable resolution consistent with the laws of the community. Again, this is not a trial, it's not a hearing, it's a dispute resolution to come to some amicable resolution that's suitable for all, but also follows the laws created by council. It's an opportunity to have both sides heard and agree on those terms, and it's binding. You can have these as confidential proceedings, and they can be open to the public or not. If there's sensitive issues in that, then it can be closed to the public. The resource staff has developed training sessions on composition and protocol, how to read and consider a section of a law, how to read your laws. You're not supposed to be lawyers, but there are considerations when you're reading the law. Boundaries and consistency. Having judicial fairness and consistency on your decisions is very important. Ultimately, writing a decision. Writing a decision is putting basically a summary, how it relates to the law itself and the decision of the panel and the board. Part of the training is to have a mock session for the panel. Those mock sessions and hearings are set up not to trick anybody or that, but to demonstrate to the panel how to go through the process and have a hearing. So again, it's very valuable to have a hands-on session and actually be able to write those decisions. Next slide, Sean, please. Most of the enforcement team have a knowledge-based experience, and they have extensive experience in the field of enforcement, either through inspections, investigation, been part of prosecutions and court procedures. Some of our staff are lawyers, and they can be accessed dealing with legal opinions, research, drafting of reports. The enforcement team, through the technicians, will work and support the committees assigned to develop and write the laws, assist in the development of a records management system and requirements. One of the areas we haven't touched on, and that is having some way of securing your documents, writing reports and writing notes and keeping them and compiling them for Crown briefs. The enforcement team does not replace the need for independent legal counsel. The enforcement staff has and will continue to support decisions and direction by your legal counsel. In choosing a lawyer, ensure that the background and strengths provide for the best legal advice, as there are many fields of law. As in many professions, there are many areas of expertise, and in the development of your laws, a lawyer who has a strong background understanding law development and prosecution is most desirable. As my background is from policing and Gail's is from policing with the RCMP, we can help you develop the laws, but we can't provide legal advice. That comes from your legal counsel. And once the committee feels that they have a significant draft, then they would engage with their legal counsel. And we engage with your legal counsel as well in developing these draft laws to put before council. Next slide, Sean, please. At present, the Resource Center is engaged in supporting one major project following the 3 steps in land development, community and local provincial government engagement and internal mechanisms. One of the other projects has stalled and is in the process of being re-engaged. Project proposals include not only a court-driven solution, but exploring more traditional and community-based approaches. Other solutions involve the discussion of how community groups can support the compliance of laws along with the resolution of any conflicts or disputes. Any projects are First Nation-led projects with support from the resource staff, assisting from both technicians and specialists. There is no direct funding for enforcement operations, but for the development of an enforcement strategy, training of personnel, both from the nation and local enforcement staff. So some of the projects that we have and are continuing to support is the Comox pilot project, which was the taking the incident, filing it in court, working with the law firm, and going through the court process. The Whitecap Dakota Muscadet pilot project partnership with the provincial government to adopt and enforce provincial environmental laws. And this project is ongoing. The Member 2 pilot project. We're developing an enforcement strategy for good First Nations laws and promote partnerships with the regional policing agencies to assist in the enforcement of those First Nations laws. Each proposal is carefully screened and vetted and submitted to the Resource Center as a proposal, and we work through the various steps to get approval. The Member 2 pilot project will work on an enforcement strategy, not only to identify those areas of enforcement, but also to develop the laws that Member 2 feels they need to provide enforcement. There will be engagement with the Cape Breton Regional Police, which is the police service that serves Member 2, just outside Sydney, Nova Scotia. And there will be a training component for their officers to understand the framework agreement, their land code, and the application of those laws. Next slide, Sean.
Well, thank you so much, Kevin, Gail, and Michelle. I think that was incredibly informative and was a really great sort of foundation for the types of activities that operational First Nations are undertaking and the many options that are available when it comes to both law development and enforcement. So we have a number of questions in our chat box. So if it's okay with our presenters, maybe we could start there. Our first question is from Cindy Collins. And she asked, we have, I guess it's a comment, we've had trouble getting SPCA to come on reserve to pick up animals.
I can answer that one. Hopefully you're from BC, and the SPCA may work different from province to province, but I'll speak for BC. You should get, if you don't have already, an animal control law written up for your community if you're in land code. The SPCA will come in communities, First Nations community or not, for neglected animals and abused animals. A lot of cases, the police force who polices your area will come and assist the SPCA with those animals. If an animal is just an aggressive animal and is dangerous, then the RCMP will look after that animal and seize the animal. Some of our communities are making agreements with our local municipalities for services, so animal control services, and they will have a look at your law, and they will work within that law that you build. And one of the things that we are working on here in the Fraser Valley is just that. And to have an appointed person appointed by your leadership or your lands manager to be a contact person for either SPCA or for animal control services if you enter into an agreement. Sometimes SPCA will enter into agreement with the First Nations community, but it's usually just for entry into a community. So if SPCA needs to go into a First Nations community, they will first make contact with someone in the community before they enter, just so that somebody in management or somebody in leadership knows what they're doing in their community. So that's kind of what that agreement would look like. There's other laws that we have in First Nations communities: dog licensing and animal management law, animal control and protection law. So yeah, if you have any other questions about animal control, you can certainly go on our website and email us, and we can certainly give you a hand. Like I said, I'm working on a project on that topic now in the Fraser Valley, so I'm very up to date on animal control.
So one of the, if I might add, many of the SPCAs work under provincial legislation. So if you're having an animal control law, those appointments that Gail was talking about provide the authority for those individuals to deal with the animals on your reserve, have to be entrenched in your laws or an enforcement law. To have them appointed, give them the authority to enter onto property and whatever they have to do within the community. So again, meeting with the local manager or director of the SPCA or even a municipality. There are agreements with municipalities that have an animal control officer. They all have to be entrenched in a law to give them the authority. So just something to remember.
Thanks, Gail and Kevin. Our next question is from, and I apologize in advance, I'm probably going to butcher this name, but Kylie Sheba-Gedget. And the question is, has the RC provided training to tribal police organizations on the framework agreement? Is the onus totally on the First Nations to engage with their law enforcement agencies on custom laws? This is what we're trying to sort out.
I can speak to it. We will provide training for the tribal police services. We've offered to speak to other police services, and again, part of the Member 2 pilot project, the enforcement project, is to work with the Cape Breton Regional Police, and we offer that service to any police service, whether it be the RCMP, any of the tribal police, or that. That's an ongoing discussion when with your local detachment or the police service itself. And either the First Nation can initiate that, or as part of the law development, at some point, we're going to have to engage the police service so that they understand what the framework agreement, land code, and these laws are. They'll also want to review the laws to make sure that it provides the authorities and processes that they need to provide enforcement, and that would be all part of the discussion and training for them. I don't know if Gail or Michelle has anything to add.
Yeah, I don't feel like that the onus is all on the First Nation themselves. Like, we will, if you contact any of us, we'll make a very solid effort to provide the training that you'd need, and any information. If it's not training, we can provide answers to any questions. They can email any of us directly. One of the things when working with Whitecap, for example, and Saskatchewan government, we provided some information sessions to the Saskatchewan conservation officers who will be enforcing Whitecap's law on their land, as well as some of the provincial regulations. So, you know, they were kind of starting off in the same boat, that they had no idea. They had, okay, we have our provincial regulations, our duties under the province, and now we're mandated to also support your First Nation laws. Like, we don't know where to start, so we can provide assistance in that if you're looking for it.
Yeah, depending on the police service and the location, there may be restrictions with the Local Police Services Act, and we can help navigate those. I'm in the process right now in Ontario doing exactly that. So again, there's many areas that we consider, and we will help you. It could be with the RCMP, and with Gail's background, help us navigate through the RCMP and who to talk to.
Yeah, I'm in BC. I'm in contact with all the police agencies. I get contacted regularly by a lot of the police agencies with questions about land code and land code laws, and what their authorities are, what the community's authorities are. So, you know, I bring the communities and their law enforcement agencies together to build on an enforcement, whether it's a criminal code enforcement, whether it's land code enforcement, and what direction is the best direction to go. So we're constantly contacting the different police forces and First Nations communities when they feel frustrated that they're getting no services. So we analyze their situation, because every situation is different. So yeah, there's lots of work being done there, but don't hesitate to give us a call or an email if you have questions, or if you're in a situation you think you need some help with.
Thanks, everyone. So our next question is from Cindy Collins, and she asked, in a rental agreement or housing policy, can you enforce losing your home if you do not abide by policy or banned law?
Well, just as say, I might need a little bit more clarification on this, but it depends whether your First Nation also has a residential tenancy law. There are some that do, and that law can be enforced for eviction purposes, as we've seen in the Comox case, of course, and other cases that will follow down the road, I'm sure. I'm not exactly sure of the specific situation. If Cindy would like to, she can send me an email to discuss if you'd like further.
The MRP law might come into play there too as well, so it could be very many different situations.
Yeah, I'm not quite sure, just from the comment itself.
Yeah.
Okay, well, Cindy, maybe we can follow up after the session, and if you can reach out to Michelle directly, or you can send me an email, and I can connect the two of you, and with a little bit more information, I'm sure Michelle will be able to give you a more fulsome answer to that question. Our next question is from Chief Donna Aljam Nickman. And the question is, I have a problem of cattle versus dog issues. Cattle owners are trying to use traditional holdings. Then with the building of houses, we also have dogs.
Again, that would be a situation where we would have to know the history of it. Existing laws within your community, are they bylaws or are they First Nations laws? And does it provide for some enforcement action and that? So again, it's one of those situations where we would have to know the background and the history of it. So.
And it shouldn't matter what land it's on, whether it be traditional holdings or CP land, they all have to abide by the laws that are enacted in your community.
So that's all of the questions in our chat box. If anyone else has any questions, feel free to type them into the chat box, or feel free to unmute yourself and go ahead and pose that question. Maybe while we wait for any other questions to come in, I've got a question for the panel. So can a provincial ticketing system be used as a tool for enforcement of First Nation laws?
Yes, I'll just step in first here. That's a situation that we've seen in West Bank initially as well. I believe they now have their own ticketing system, but under the framework agreement, you can, a First Nation can make an agreement with the province or whoever they want for enforcement of such laws, including a provincial ticketing system. Sorry, just I think. Anything else to add, Kevin?
Yeah, some of the normally the provincial offences court, and I can speak on behalf of Ontario. The provincial offences court is set up to deal with provincial offences and not First Nations laws. But as Michelle said, you can set up your own ticketing system or ticketing regime within the community, and it can be run by the community, by the band administration, and all those fines that and admin fees and everything like that are property of the band. So again, there are restrictions. There are restrictions in some of the provincial offenses legislation that restricts it only to provincial legislation.
In the Fraser Valley, we do have some communities who have their own ticketing system, and they have had that for some time. It works well. They don't write a lot of tickets. I mean, like Kevin had said earlier, writing a ticket is one of the last things you want to do. Sometimes it's more than just writing a ticket. There's other issues going on. But in our communities in the Fraser Valley in BC, we have security companies that work for the First Nations communities who issue these tickets. And then the tickets are paid at a location in a First Nations community. And it's for all residents of the community, whether you're registered in that community or if you're leasing land in that community, everything applies. Yeah, I was going to say something else and I can't remember. But yeah.
Okay, well, we've got another question from Trina Seta, and she asks, I'm curious about how this will work for the Chilcotin Nation. Is the land code still needed for a foundation to create laws?
Are they, I have one question, are they presently an operational land code?
I don't believe so.
No, I believe Silcoton has their own self-governing agreement, so we'd look at something similar to, make sure I'm not on mute here. No. West Bank or Whitecap with their self-governing agreement. So in this case, I believe a land code is not needed in this instance. I don't know whether Silcoton had prior to their agreement, started the process of a land code, started the process of enacting what would be land-related laws. I wasn't involved in that, but I could look into it though if you like.
Yeah, Trina, I think that's a quite a fulsome question, and I think that might be another one that would be really good to connect with any of our presenters. So perhaps after the session, you can give myself an email or any of the presenters an email directly, and we can connect you that way. She also asked, I'm curious as to whether, or as to where is the best place, oh, it keeps moving, to start due to my job requirements, land use plan development.
Curious.
Yeah, she's writing her.
Well, I think I can answer that. I'm not sure, but you know, I can just focus on what I know, and it's you have to build your enforcement and ticketing law. I mean, and your enforcement and ticketing law should be one of the first laws that you develop, because it brings action to all the other laws that you build. So everything you write in your enforcement and ticketing law will complement all the other laws that you're building.
Thanks, Gail. And I've got your email now. So like I say, at the end of the session, I'll send you an email that connects everyone.
Mm-hmm. I'd say we talked about the enforcement and ticketing laws, of course, but Kevin touched on a very important aspect earlier in the presentation about records management. You really need a solid system of managing your records and having these documents. So to make sure everything's up to date, to make sure you're working with the current standard, the most recent version of a law, let's say, or your ticketing, your forms, all of that has to be fairly concrete to make things easier. And I just wanted to say that for.
And it should be also limited to who can access those files if you're storing them electronically, and that just the enforcement staff and manager, it shouldn't be open to all the administration. So again, your IT people can restrict access to those folders and that. So
we've got another question. It's hi, do you have documents for enforcement and ticketing law that we can reference to or research on? Thank you.
I've been working on many different versions of an enforcement and ticketing law right across Canada. One most recently was McLeod Lake. I've got a couple here in Ontario, one in the eastern region. So if, again, Sean, you can share my email or go on the website, I'd be happy to work alongside anybody that's interested. So
there are many different variations of your enforcement and ticketing law, and like we had said before, you got to make that law work for your community, where the whole cutting and pasting of laws is definitely not going to work for your enforcement and ticketing law. So to have a look at a few laws, because they're all very different from each other, and see what works for your community.
So if there's no other ones from the crowd, I've got one other one. An issue that I've run into a number of times is police agencies being hesitant when it comes to land code laws, and it seems like there's just it's an unknown area for them, and as a result, they're not sure how to deal with it. So do you have any recommendations for what communities can do when they do approach their, their local policing agencies and they're met with that type of hesitance?
Go ahead, Kevin. You can go first. I'll go next.
The easiest way is to open the dialogue. Both the RCMP, local police services that are servicing First Nations communities have what they call liaison officers, and that's a place to start. If you set up a meeting with the detachment commander or the divisional commander, whatever the setup for the police service is, and reach out and have those meetings through the technicians, Gail, myself, Michelle, we can sit in virtually and provide any guidance or assistance when dealing with the police services. Understanding what land code is a fundamental piece of it, and the recognition that these are an entirely separate group of laws set aside from federal regulations, provincial legislation, or even Indian Act bylaws. It's an education for the police agency. The second thing that I would come, armed with some knowledge is your existing laws. Does your laws provide for the authority for the police to do what you're asking the police to do? Enter onto property, prevent people from accessing, especially in this era of COVID. Does your emergency management laws or your emergency COVID laws or your bylaws actually speak to preventing people from entering the community? And what enforcement action does your law provide? Again, when you're writing your own laws, you've got to provide the police service the tools to do what they have to do. So it's not just that they're police officers and it's a blanket authority to arrest somebody or go onto somebody's property. Those authorities have to be provided for in your laws. So again, opening that discussion, and we're having those discussions more and more. Again, just take BC, there's the tripartite agreements and the level of enforcement agreements at the local level. Engage your police service, be it an inspector, a staff sergeant, whatever, and we can help them with that. So again, it's not that we want to get bogged down in documentation and stuff like that, but we need, if you want a certain level of enforcement, it has to be written in these agreements with the RCMP, the OPP, and even tribal police. So again, each area, each police service is different, and we need to have that discussion.
We can help you with your policing agreements. If if you want some wording that you would like in your policing agreements that pertains to land code, certainly give us a call. But I'll tell you my own little story about land code and land code laws as a police officer. I retired 3 years ago from the RCMP, but before that, working in the First Nations communities, I had no idea what land code laws were. I had no education at all. So my own community invited me to sit on their LAC committee, their lands advisory committee. So as a police officer, I sat at that table, and it was most informing, and I learned so much. I learned about the laws, where they came from. I learned about the framework agreement. I brought that back to the detachment I was working in, and I was actually lecturing my own members I worked with about land code. So we were fortunate enough in the Fraser Valley here that we knew a little bit about land code. So I guess my message is, if you have liaison officers, if you are in a tripartite agreement with a police force, invite them when you're reviewing your laws, and just educate them. So education is key, and we'll just keep taking those steps forward for with enforcement. And so yeah, that's my 2 bits worth.
Awesome. Well, thank you so much, everyone. So just in closing, anytime you're looking to access any of our presenters or anyone from the First Nations Lands Management Resource Center, just reach out to your support technicians or the regional managers, and they will be able to connect you with whomever in our staff is going to be able to best assist. And just go on our website if you're having troubles finding out who your support staff is, and you should be able to find it on there. Another thing that all of our team is really great at doing is if there's any committee meetings or chief and council meetings or anything like that, our enforcement team can join any of those meetings and provide presentations on the development of laws or enforcement or any of the topics that we might have touched on today, or more specialized topics. So again, we want to thank you all for taking the time to participate in today's breakout room, and we look forward to supporting the great work that you and all of your communities are doing. I hope everyone enjoys the rest of the sessions today, and have a wonderful afternoon. Thanks so much.